So in summary, this is a 26-year-old man who is charged with a count of harassment following some incidents with a woman in his neighborhood. He had the belief that she was flirting with him when she turned the lights on and off of her apartment, and he knocked on her door, yelled at her, made some signs that he hung in her window, such as choke and ugly bitch. And he yelled things at her when she walked by from behind a fence. My diagnostic formulation for Mr. Allen is based on my observations that he has impaired attention, he has a hard time tracking information, and this seems to come because he's distracted from internal stimuli, that he may be perceiving things such as hearing things or otherwise perceiving things that are distracting him. He's also preoccupied by religious thoughts and has perseverative thought processes which are with irrational and delusional content. His intellect appears intact. Mr. Allen denied symptoms of mental illness, but his presentation and his history is highly suggestive of a thought disorder. In addition, he has a history of some problems with alcohol, marijuana use, and a couple of prior convictions. My diagnostic formulation is psychotic disorder, not otherwise specified. I can rule out a delusional disorder, rule out possible schizophrenia, rule out substance use disorder. And my overall findings in terms of competency is that he's able to state the charges against him, but he lacks a rational understanding of his legal situation. He understands the roles of the courtroom participants, but his irrational and delusional beliefs get in the way of his ability to talk about his case, to talk about realistic legal options, and get in the way of being able to make rational decisions regarding his defense. In addition, the way his thought processes are, that would get into the way of his ability to talk with his attorney, provide information to his attorney, and provide any rational testimony if that was required of him. So my opinion is that due to these symptoms of mental illness, Mr. Allen lacks capacity to understand the nature of the charges against him and lacks capacity to assist in his defense.
Thank you, Dr. Piasecki. I want to flush out some of what you had testified to. Is it a best practice when you are conducting a forensic evaluation for competency to assess information from collateral sources?
Yes, it is.
Why is that?
The collateral sources are very important because the defendant may not be able to remember, or their thought processes might be affected by illness, and they may not be able to report accurate information about their history or about the events that led to their legal situation.
How many collateral sources did you review in preparing your report?
I used 5 different sources of collateral information.
Which 5?
I used the jail records, I used the information from the county crisis commitment services, I reviewed his, there was a computer database which I had access to. I was able to talk with his father, and there were some additional booking records that I was able to review.
Why were they important for you to review?
They were important because Mr. Allen was not able to accurately recall and report his history.
What degree of reliability did you place on those collateral sources?
I thought they were highly reliable.
How did you assess the reliability of those sources?
I thought they were highly reliable because they came from professional institutions, and the individuals who completed the reports from the crisis and commitment services were licensed mental health professionals.
Did you review those sources before or after you met with my client?
I reviewed them before I met with him.
How long was your interview with my client?
It was about 70 minutes.
Was the information you obtained from the collateral sources consistent or inconsistent with the ultimate opinion you reached that my client is not able to stand trial?
The information that I received from the collateral sources was very instrumental in helping me understand his background. However, it was the clinical interview that I had with your client that really provided the basis for my opinion.
Okay. Was the information you obtained from that interview consistent or inconsistent with the collateral sources in terms of the impact on your assessment of my client's condition?
I would say it was generally consistent.
You mentioned in your report that my client denied any prior assaultive behavior and denied any drug use. Did you consider that denial to be accurate or inaccurate?
I thought that Mr. Allen was having difficulties recalling or reporting that. I found the collateral to be more reliable than his report.
In terms of use of drugs or assaultive behavior?
Yes.
Did you consider whether my client was simply being evasive or secretive in denying that prior history?
I did, but there were other parts of the interview where he was very forthcoming, gave details about difficulties he had had, so it did not appear to be merely self-serving that he wasn't including that information. It seemed as though it was not just evasiveness.
You also described my client as exhibiting religiosity and delusions. How did you differentiate, or how would one differentiate between religious fervor and delusional religiosity?
I think in the case of Mr. Allen, what was most striking to me is that he would make religious comments with no context whatsoever. So when I was asking him about his mood, he started to make religious statements completely out of context. To me, that's more representative of hyper-religiosity than just religious fervor.
Okay, I have just one moment. Why would the religiosity or delusional behavior interfere with my client's ability to work with me?
If he had fixed false beliefs that related to religion or related to his situation, he would not be able to have a rational understanding of what his problems were. So, for example, if somebody had a religious delusion that they were, because of their special relationship with God, they weren't subject to men's laws, or because of their special relationship with the victim in this case, that there was no crime, those kinds of delusional beliefs would definitely get in the way of them being able to work with their defense attorney and have some kind of rational approach to their legal situation.
In your report, you noted that my client appeared to be responding to internal stimuli. Pardon me. How would that impact his ability to work with me on his case?
My observation with Mr. Allen is that he appeared distracted, had a hard time paying attention, poor concentration, and at times I had to ask a question 2 or 3 or 4 times. I thought all of those would be potential impediments to working with his attorney.
You also described my client as having difficulty concentrating during the interview. Did his lack of concentration continue throughout the interview, or was it sporadic?
It continued throughout the interview.
My client indicated to you that he was sleepy. How is it that you're able to determine that his lack of concentration was due to mental illness rather than due to being sleepy?
Usually when people are just sleepy, they are initially sleepy for a period of time, and then they come out of it. They become more alert as their brain wakes up. I thought that his presentation was much more consistent with somebody who was experiencing internal stimuli and other kinds of symptoms related to mental illness.
You described my client as perseverating on his delusion that the victim was flirting with him, and my client indicated that you indicated my client would not return to the matter at hand. Why? Do you have an opinion about why he could not be brought back on topic?
It was my impression that Mr. Allen was so preoccupied with the, with his false beliefs about the victim flirting with him, that he could not change track to another topic. He was just so focused and preoccupied on that one topic.
Based on everything that you observed about my client, based on everything that you received from the collateral sources, based on the interview with my client, and based on your training background and experience, what is your opinion about my client's ability to assist in his defense in light of his mental illness?
My opinion is at this time he lacks the ability to assist in his own defense based on his mental illness.
Thank you, Doctor.
Doctor, my name is Mike Sage, and I'm a prosecuting attorney. I'm going to ask you a series of questions, and if at any point you don't understand any of my questions, I want to make sure that you stop me and ask me to rephrase the question, and so you and I can be very clear of your answers. Will you agree to do that?
Yes.
Now, doctor, when you did this examination, it was at the county jail, is that correct?
Yes.
And you frequently go to the county jail to conduct these types of operations, is that correct, or these types of examinations?
At least once a week.
And doctor, you're aware that the county jail has a special unit for people who are suffering from psychological impairments, is that correct?
Yes, they have a mental health unit.
And they get there because they have been screened by mental health professionals, and if they're in need of psychotropic medications or psychiatric care, they're put into that unit, is that correct?
Yes.
Now, in this particular case, this particular defendant was in the general population, is that correct?
Yes.
And he was not in any kind of psychiatric unit. Would you agree that that would be based upon the jail and the social worker's evaluation of him at the time of his admission?
That would be based on the booking screening that they do, yes.
Okay. And again, so we're clear, your opinion is based upon an examination which lasted approximately 70 minutes, is that correct?
Yes.
And again, prior to interviewing this defendant, you explained to him the nature of your examination, is that correct?
Yes.
And as a result of that, you found that he had a good understanding of what was happening in the purpose of the examination. Is that correct?
Yes, he did.
You also concluded that he voluntarily agreed to participate in this examination. Is that correct?
Yes.
Okay. And again, at the time of his arrest, your history indicated that the defendant was not on probation or parole. Is that correct?
That's,
And further indicated that he did not have any history of any kind of felony arrest. Is that correct?
that's correct.
And at the time this incident allegedly occurred, the defendant was working as a cement mason. Is that correct?
Yes.
And he worked with his family. It was a family business, and he was able to conduct his occupation up to the time of his arrest. Is that correct?
Yes.
And again, the defendant was a fairly accurate historian. Is that correct?
About some information, he was fairly accurate.
Well,
yes.
he was able to give you an accurate history of his family. Is that correct?
Yes.
And again, he gave you no history of any type of developmental problems as a child.
Correct.
Okay. Now, you also found that there was no history of any kind of psychiatric hospitalizations. Is that correct?
Correct. He had not been hospitalized previous.
And in fact, you found no history at all of any type of mental health treatment. Is that correct?
He had been assessed. I believe that was the...
Doctor, my question is very specific. Not assessed. You found no history of any type of mental health treatment. Is that accurate?
Correct. All I have is information about 2 referrals.
Okay. And in fact, there were 2 referrals made to mental health institutions. And as a result of that, they found that there was no need for any type of mental health treatment. Is that correct?
There was a diagnosis of attention deficit disorder listed in a database, but I didn't have information about treatment.
Okay. Well, that was my question. As a result of these 2 encounters, there was no any type of legal intervention or referral to a mental health institution for treatment. Is that correct?
Correct.
And again, as a result of your examination, you believe that the defendant cooperated through this examination. Is that correct?
Yes, he did.
And in fact, according to your notes, he was alert and oriented to person, place, time, and situation. Is that correct?
Yes.
And by that, you simply mean there was no psychotic break from where he was at or what was going on.
He knew that he was in the jail. He knew the date. So yes, he was generally oriented.
Okay. And again, you also found that his thought processes were fairly well organized. Is that correct?
Yes.
And you also found that his thought processes were goal-directed. Is that correct?
Yes.
What do you mean by that?
What I mean is that within his own thoughts, he was logical. So even though he might be talking about something that wasn't reality-based, even though he might be talking about the fact that he thought the victim was flirting with him, he was able to describe his thoughts in a way that was linear and logical.
Okay. And again, you found that the defendant's immediate recall and really memory for recent and remote events were unimpaired. Is that correct?
Yes, I thought that he was intellectually intact.
Okay. And you found that the defendant was experiencing no problems with such issues as appetite, sleep patterns, or energy levels. Is that correct?
Yes.
If a person had diminished appetite, an altered sleep pattern, or a diminished energy level, that would be strongly indicative to you of something that would suggest a more severe mental health problem.
It would suggest a certain kind of mental health problem, not
Okay.
necessarily more or less severe, but another sort of mental health
Okay.
problem.
But again, you found no diminished appetite or change in sleep patterns or energy levels. Is that correct?
That's correct.
Okay. And again, when you asked the defendant directly, he denied experiencing any type of psychotic symptoms. Is that correct?
That is correct.
And again, you asked the defendant, in fact, whether or not he knew what the charges were and was able to accurately reflect to you what he was charged with and what those charges meant.
He was able to state that he was being charged with harassment, trespass, and stalking.
And you asked this defendant, again, what were the roles of the various participants in the courtroom, such as the judge, the prosecutor, and the defense attorney. Is that correct?
Yes.
And what did he indicate to you?
He responded with accurate information, that he understood those roles and he was able to describe them, demonstrated his understanding.
And in fact, he also understood courtroom procedures.
Yes.
And that's something very important for you when you evaluate a person for competency as to whether or not they understand courtroom procedures. Is that in fact?
Yes.
And in fact, he even discussed with you his legal strategies in this particular case.
He talked about some potential ways that he thought about his legal situation. I'm not sure they were rational, but he was able to talk about his legal.
Well, in fact, Doctor, he did in fact discuss his legal strategies with you. Is that correct?
Yes.
Okay. And again, Doctor, there are a number of standardized tests which are available to a doctor in making some type of diagnosis. Is that correct?
Yes.
And really, you have diagnostic tests, but there are other types of tests you could have administered. And for example, the MMPI is one. Is that correct?
Yes.
What would be other tests that you would normally use in an evaluation such as this?
For a competency evaluation, there's a number of tests that could be used. There's something called the FIT, which is a fitness interview test. There's the MacArthur Competency Assessment Test for criminal adjudication called the MAC-CAT. There's a number of tools that are available for competency assessment.
And those tools were available while you conducted your very brief 70-minute examination. Is that correct?
Yes, they were.
And you chose not to use any of those tools which are statistically, scientifically validated. Is that correct?
Correct. I relied on a clinical interview.
And again, there are other types of tests which are available not only for diagnostic purposes, but are tests which are available that measure such things as malingering and fakery. Is that correct?
There are some malingering tests, yes.
Okay. And what would be some of those tests?
The most commonly known is something called the SIRS, which stands for Structured Interview for Reported Symptoms.
Okay. And again, even though you had those tests available, you chose not to administer those tests during your brief 70-minute examination. Is that correct?
That's correct.
Okay. And doctor, finally, the last thing you did was you came to a diagnosis. So this was just a general diagnosis of a psychotic disorder. Is that correct?
Right.
And there was not sufficient evidence available to you during your brief 70-minute examination to make a diagnosis of schizophrenia, correct?
Both the limitation of collateral information as well as the interview together there wasn't enough information to be more specific than psychotic disorder not otherwise specified.
And the same thing is true, you couldn't make it a diagnosis of something like a bipolar disorder or a schizoaffective disorder, is that correct?
Correct.
And you found that there was no evidence of any type of axis 2 personality disorder or any type of axis 3 medical information which was affecting this defendant's ability to assist in his own defense, is that correct?
Correct. And there's no diagnosis for personality disorder or for medical problems.
Thank you very much, Doctor.
I'll waive redirect.
Okay.
Your Honor, it's clear in this case that my client suffers from a mental illness. As Dr. Piasecki indicated, my client is afflicted with psychotic disorder not otherwise specified. That meets one of the prongs of the test for competency. There's no issue about whether my client understands the proceedings. That came out in both direct and in cross-examination. So that's not an issue either. The issue then is whether my client has the ability to work with me in his defense. Notwithstanding cross-examination, the manner in which the examination was conducted by Dr. Piasecki establishes its reliability. She had 5 collateral sources that she reviewed prior to the interview. She conducted a 70-minute interview which led to conclusions that were consistent with the 5 other collateral sources of information. So from the defense perspective, it was much more than merely a 70-minute interview. Dr. Piasecki testified that my client could not recall prior assaultive history and prior drug use. The fact that he might be able to recall other matters is not what's important. What's important here is those are facts that would be memorable. Those are facts that would be important for his attorney, me, to know. Those were the facts that he couldn't remember. Any other facts that he could remember are irrelevant. In terms of delusions and internal stimuli, Dr. Piasecki testified that my client was at that time and appears now to be suffering or to be reacting to internal stimuli and delusions. What that means is that he would not be able to follow my directions. He would not be able to listen to my advice. He would not be able to take in and understand what I'm saying to him because he would be distracted. The delusions need not be universal and impact every aspect of my client's life to interfere with his ability to work with me. For example, the fact that he could eat breakfast in the morning, tie his shoes, know what day of the week it is, unaffected by delusions, would not really impact whether he could work with me on the case. The fact that he's delusional in terms of his religious beliefs, that he attaches everything in the case to those beliefs or the delusions about the victim, indicate that they are impacting his ability to work with me and to talk with me about the facts of the case. My client also was noted to be perseverating. He would not get off of a topic. He couldn't change what he was thinking about. Part of my job as a defense attorney is to suggest alternatives. If he is fixated on one and cannot consider the others, either because he's perseverating or because he's suffering from delusions, which of those occur doesn't matter. The fact of the matter is he is not able to change topics at any rate of speed, which means prior to trial I will have difficulty speaking with him. During trial, for anything that I have to discuss with him during the course of the trial or ask him about things that are happening during the trial, he will not be able to do because of that perseveration. The bottom line in this case is delusional behavior, internal stimuli, and perseveration are going to interfere grossly with my ability to work with my client and my client's ability to work with me. On those bases, we're asking you to find that my client is not capable of proceeding based on the prong of unable to rationally assist counsel. Thank you, Your Honor.
If it please the court, the crux of this case is that simply that this psychiatrist and this defense attorney believe that simply because a person suffers from delusions means that they is therefore mentally incompetent and is unable to assist in his own defense. But the facts of this case, I believe, very strongly indicate just the opposite in this case. Your Honor, this defendant is being held in the general population of the county jail. They have a special psychiatric unit which is available for people who are suffering from psychological problems. There they can be appropriately treated and prescribed medications. This defendant was not. This was a brief 70-minute interview. The doctor indicated that, in her opinion, he had a good understanding of what was happening and that he voluntarily agreed to participate in the examination. That this defendant before and at the time of this particular offense was able to work every day as a cement mason, was in fact working in his own family business at the time this was going on. That the defendant, other than being able to not remember his criminal record, was otherwise a fairly accurate historian. Again, he and his family both denied any history of developmental disorders. Equally important, there's no history of psychological problems in this particular case. This defendant has never been treated for any type of mental disorder or hospitalization. And in fact, as a result of some type of minor referrals to a crisis center on both occasions, they found that any type of legal intervention or psychological intervention was inappropriate. The doctor believed that the defendant fully cooperated throughout the examination. She found that he was alerted, goal-oriented as to person, place, time, and situation. This doctor found that the defendant's thought processes were generally organized and goal-oriented. He had the ability to recall immediate, recent, and remote events, and that ability was unimpaired. He had no problem with his appetite, sleep disorder, or energy level, indicating some type of serious psychological problems. This defendant, when he was asked point blank whether he had any psychological problems, he adamantly denied having any problems, Your Honor. Most importantly, this defendant was able to know the charges against him. He understood the roles of the court, the prosecutor, and his defense attorney. He understands the criminal procedure, and he in fact discussed with the doctor his legal strategies in this particular case. Your Honor, when you consider the validity or the strength of the weight that you should be given to Dr. Piasekhi's report, please consider the fact that even though she had the opportunity to administer a number of diagnostic tests, she chose not to do so, which would give some type of validity to her findings. Equally important, there are also a number of tests which would be appropriate in this particular case for malingering or fakery. And again, she chose not to administer this. And what's important is that she made a general diagnosis of a psychotic order, but she was not able to make any specific type of axis one diagnosis such as schizophrenia, schizoaffective disorder, or bipolar disorder. And so based upon the fact that what the evidence is and not what the conclusions of the doctors are, I believe that Your Honor should make a finding that the defendant is competent to stand trial.
Much as I'd love to, I'm going to waive rebuttal argument. Okay, so we're finished with the trial. So I guess first thing I'd want to know, let's hear some discussion from the jury of judges. Competent or not competent? And I don't mean Judge Sage and I. Somebody want to throw a hand up? Anybody?
No.
How many nods? Just show of hands. How many nods? Okay, and I can't see through cameraman. How many competent? The real case was not competent. Whew. God, I would have felt bad if I lost that one. Sorry. We're done. Yeah, you can act normal again. Yeah. Yeah.
They cannot determine whether it's schizophrenic or not, from an NJC interview. What does it take to diagnose schizophrenia?
I think you got to ask Dr. Piasecki or Dr. Freeze.
The question again, please?
What does it take to rule out schizophrenia or rule it in? How do you diagnose it?
Well, you've got 5 symptoms. You need 2 of the 5. The 5 being hallucinations, delusions, cognitive difficulties, disorganization are negative symptoms. So if you've got 2 of those, and currently you must have those for at least 6 months in order to qualify for the diagnosis of schizophrenia.
So you need 6 months to diagnose it.
Yeah, if you only have 5 months, you can't make the cut for schizophrenia. You would give another diagnosis.
But you can also have a diagnosis by report. Mr. Allen could have said, I've been told in the past that I'm schizophrenic. That doesn't necessarily mean that Dr. Piaseki's diagnosis would become schizophrenic, but it's something that would have made its way into the report. And one thing that probably would have been nice if I'd asked is psychotic disorder not otherwise specified considered an Axis 1 diagnosis? It was on our Axis 1 chart. As I understand it, it's basically they meet some criteria of psychosis, but there's no clear category into which it falls.
There's just not enough information or enough time to be more specific. So it's in some ways a placeholder diagnosis that indicates this person has psychosis, and until I have more information, I'm going to just put this placeholder diagnosis, and then over time, with more observation of the individual or more collateral information, I would be able to refine it to a more specific diagnosis.
Okay. Other questions?
Is 70 minutes a normal or average time for the interview?
For this kind of legal situation, I would say yes. If it was a capital case, then it might be a whole day because of the complexity and stakes of that kind of case. So it's, in some ways, it depends on the kind of case.
It also, I think, depends on the culture within the jurisdiction. So this was done by Western State Hospital, and actually that's probably 10 to 20 minutes longer than they would ordinarily do. So, the culture there, and this was an in-jail evaluation. If it had been done at the hospital, it would have been by 2 doctors, and it would have been a large number of hours over a 2-week period.
This was based on a real case, you said?
Yeah.
I mean, this guy had a lifelong history of symptomology, throwing his dad's coin collection in the street at age 3. How come there weren't any outside medical records?
It depends on where he spent his childhood. It depends on how much time the evaluator had. It depends on what records they have access to. King County has a record-keeping system for all public mental health service providers and usage. If someone's from Pierce County, it isn't going to show in the King County, so they may not have it. Sometimes the parents are mentally ill also, and they may not have taken them in for any assessment. They may be enabling type parents, in which case they're...
Was the father mentally ill in this case? He thought his son was very successful and had an IQ of 140.
The father was not... he certainly didn't have what I would call an Axis 1 diagnosis. I have no idea if he had an Axis 2 or not. But, I mean, he was cogent. You could carry on a conversation with him. You could talk about the case. You could talk about his son. For all I know, he's got... I mean, you can have delusions that only affect part of your life. He may have a delusion, my son's a genius with 140 IQ, and everything else is non-delusional. I mean, that's certainly a possibility.
In the real case, was this gentleman restored to competency?
He wasn't on this case. He committed a new criminal act, and for some reason he was competent, and maybe he was taking medications that he was prescribed, but he became competent, and then he opted into mental health court. And when I left to take the bench, he was doing very well. As a matter of fact, he was, med compliant, articulate, had a better hairdo. But yeah, he was that way. Yes?
I didn't find it really that earth-shaking that, let's say there was no other evidence that he had other symptoms or displayed this type of behavior before, because isn't it true that frequently these things don't surface until the 20s?
Well, certain, I think, mental illnesses, maybe Dr. Piasecki and Dr. Fries can address this, that like schizophrenia is a disease that I understand emerges, in that time frame. But I think that there are other diagnoses, such as bipolar, are made at a much younger age. But I don't want to speak as an authority on that.
I think of young adulthood as being the prime window for new onset of serious mental illness. Sometimes you can trace it back to the teens, but I think the college age years tend to be very, a very common time for people to first present, especially with psychotic disorders.
Yeah, and that's, interestingly though, that's not universal, because I have had a case where it was a man who had his first psychotic break and he was 45.
About 90% of those who will come down to be diagnosed with these disorders will be diagnosed with them between the ages 15 and 25 for males, 15 and 30 for females. However, that leaves 10% of those when they're first diagnosed will be outside of that range. Also, importantly, these disorders, psychosis, bipolar, or schizophrenia, tend to develop starting 3 or 4 years before the first official diagnosis is given. So there's all of that needs to be factored in with regard to setting the age range.
Question?
The report had indicated that during the course of the interview that your client appeared to be distracted, internally stimulated, was reacting to that. She made that comment during the hearing. Obviously he was well coached, and I was looking based on that information for some corroboration during the course of the proceedings, and I noticed that he was playing with pieces of paper and tapping you in the back, and so
he was supposed to be in there.
No.
Wasn't his
I know.
one. Yeah.
But given that the recommendation was a fairly brief period for some further observation and treatment, and given what I was witnessing, that there might be some difficulties in a longer proceeding.
And Washington laws, I don't know if it's similar to your jurisdictions or not, but one of the things they're required to do is render an opinion about whether the person should be referred for civil commitment if they're not, whether or not they're restored to competency. I mean, either way. And so some of that is there is a line in there about referral for treatment, and they're also required to give an opinion about whether the prosecution should seek involuntary medication authority. And that's the little bit in there, although, quite frankly, this was actually written by a psychologist in real life. And so I don't know how a psychologist who doesn't have prescribing authorization or, licensing can say whether involuntary medication is necessary, but I'll leave that to the experts.
I know it's not relevant in this case, but to the doctors, can substance abuse cause psychosis, non-specified origin, or just a mental illness?
Substance-induced psychosis?
One of the things that I see a lot of is methamphetamine-induced psychosis. It's a real co-occurring problem, and we get into chicken and egg problems. What happened first, the psychiatric problems or the methamphetamine problems? Methamphetamine is such a good producer of psychosis, not that we would want it, but in order to research drugs to treat people with schizophrenia and other psychotic illnesses, we create schizophrenia in the animals by giving them amphetamine. It's a very predictable kind of problem resulting from this drug. Cocaine to a much lesser degree, but methamphetamine-induced psychosis is fairly common, and many people have both acute as well as chronic problems that result from methamphetamine use.
As mentioned by Dr. Chamberlain, I just returned from the International Congress on Schizophrenia Research. No question that marijuana also, particularly in its more recent, stronger versions that are available now, no question that ups the probability of someone coming down with schizophrenia symptoms by at least twofold, and in vulnerable individuals, it can be as much as tenfold.
You did say marijuana.
With a capital M, yes.
Wow.